So I'm going to talk about trust funding. So this mostly will apply to people that have set up revocable trust with us. So if you remember when we started the process, we asked you to fill out a form called the personal information form. That way we could find out what you owned so that when we set up your trust, we could coordinate the assets that you owned with the trust. So you could end up after your trust was set up with still owning assets in your own name. Those would normally be assets that have a beneficiary designation that applies upon your death. You could also have assets owned in the name of your trust. So we would review what you had, and then after the trust was signed, usually at the same time, we would what we call fund the trust. Sometimes, depending on the financial advisor you're working with, they may actually prepare the forms to fund the trust for the assets that they have for the accounts you have invested with them. It just depends on who we're working with. Many times we fill those forms out, but others have very close relationships with their financial advisors, so we do that as teamwork. So the goal is when you're done with the trust, the initial trust setup, your trust is fully funded. And what we want to make sure is that it keeps fully funded. And this is something that Mark and I mostly encounter because we're dealing with post-death administration. So we've gotten a good idea as to where trusts that started out funded may end up having some assets that aren't any longer properly coordinated with the trust. So these are some of the problems that could be encountered. If there's assets that don't have a beneficiary on them, that are in the sole name of an individual, it could create a probate. And that's one of the things when we counseled you on whether you wanted to set up a trust or not, that almost everyone wanted to avoid. They wanted to avoid probate. They wanted to make things easy for their family members and have some of that asset protection that Stacy talked about in her first presentation. So probate, it costs money. There's time delays. Not only does it cost money if you have to hire an attorney to help you, but there's inventory fees, and then it becomes a public record, which most people also want to try to avoid. If the trust is properly funded, we can also provide some advanced tax planning that you might not get with a probate. And then asset protection, which Stacy talked about, and then also delays. There are built-in delays in the probate process that make no sense. You have to file a notice to creditors. It can be 4 months then before you can move on to the next step. So we want to avoid probate, and one way of doing that is with a properly funded trust. So this is where a trust review can be very helpful. Now, you may be able to do this yourself, but if you have questions, this is something we want to handle when you sign up for a trust review. And this is the new front page of our personal information form. So when you call in and talk to Annette or Teresa after this program and say, we want to have a trust review, they're going to look in your file and they're going to find out when the last time you filled out one of these forms was. And if it's more than a few years, they're going to send you a blank one and ask you to start over from scratch. If it was more recent, they may take it easy on you, send you the most recent one and let you just mark it up and send it in. So unfortunately, some people that do reviews, they have something very specific in mind they want to talk to us about, and they don't bother filling this out. So it is an important part of the process. When you come in for a trust review, we really want to also make sure that your trust is still properly funded. So here are some of the commonly missed assets that we've seen over the years. And the first one here is real estate owned outside of Wisconsin. Now that's a very important one for a single person and for a married couple, because we have a lot of tricks for a married couple. If you own property in Wisconsin that you forgot to put in your trust, and we're not telling you to do that, but if you did, we have about 2 or 3 ways that we can get that property into the trust without having to go through probate. If that property is outside of the state of Wisconsin, we lose that opportunity. So we want to make sure that if you acquire property outside of the state, you either let us know, hopefully before you acquire it, but at least right afterwards, so we can get it tied into your estate. Some people have savings bonds that they may have gotten as some promotion, or they were part of a payroll savings program that used to be popular years ago. And those are also items that we find out. We've had as many as $75,000 worth of bonds that people forgot to tell us about when they initially set up their trust. And that created a very, very long process. The funds were finally provided to the beneficiaries, but it can take 4, 5, 6 months to transfer ownership of assets with the Treasury Department. Here's another little tricky one, and it says stock shares. And it could be any paper certificates that may be stuck in a banker's box or a safe deposit box. But the 2 that we see most common are shares of Prudential Insurance Company or Metropolitan Life Insurance Company, which actually I think is split into 2 other companies. And the reason for that is a lot of people, when they were growing up, bought life insurance or had parents buy life insurance for them in either Prudential or MetLife. Those companies went through a process. They started out as mutual companies, and they then became stock companies, and the process is called demutualization. And what they did is they issued stock shares to the policy owners based upon how much insurance they had. So it might be, oftentimes we see 40, 50 shares, and that will be enough to create a problem. So look for those statements that come in usually on a quarterly basis. Those companies pay dividends. They pay a dividend. You get a statement. It would show how many shares you own in certificate, and that's something that you want to take care of. And then the last circle there is new accounts that you may have switched financial advisors, gone to a different bank. I won't slander any banks here in public, but there are some banks that used to be very friendly to the people of our community that have ended up being not so nice to work with due to changes in ownership. So people move their accounts from those banks, but they forget to update the ownership of the account in the name of their trust. And that could be a bank account or it could be an investment account. So those are the assets that we've seen missed. And here's just a few common mistakes. If you have a safe deposit box, first of all, do not put your estate planning binder in the box. This red book, we want it to be easily accessible to your successor trustees. And even though we want you to rent the box in the name of the trust so your successor trustees can get into the box, but oftentimes the things that are in the binder might be helpful to get them that authority. So please don't keep the estate plan in your safe deposit box, and make sure that if it is rented, it's rented in the name of the trust. problem we see is somebody will put a child on, and the person at the bank will name them as a power of attorney. So while you're alive, the child can get in the box. After you pass away, the power of attorney is no longer valid. They lose the right to get in the box, and we may have to do something called a special administration, and I think they're running about $1,000 just to get into your box, because you have to go through many of the same procedures as probate just to get into that box. The next one there is the IRA beneficiary. And this has changed over the years because of some of the changes in tax planning. But now, if you're married, we want to make sure that your IRA primary beneficiary is your spouse. And then the trust should be the contingent beneficiary, so that that IRA account can get the asset protection again that Stacy explained how asset protection works. Now, if you're naming your children outright, they're all perfect marriages, perfect driving records, a lot of insurance and a lot of umbrella insurance, and you want to name them outright, then you could name your children as the contingent beneficiary on a retirement account and not the trust. And the same thing goes for assets, life insurance policies, things of that nature. We usually recommend naming after the spouse, or even for the first death, naming the trust as the beneficiary of insurance. But definitely, if your children are getting outright distributions, they're not getting a trust that Stacy had the diagram, and remember she talked about crosshatch. If they don't have crosshatch on their on that flow chart, then it may be appropriate to just leave the life insurance to them outright. And then the final thing I wanted to mention is, if you acquire new property, and especially we're talking about property in another state, make sure to get that real estate in trust, or if it could be just a new investment account, try to make sure that you keep your trust funded, because even though we have a lot of tricks, fully legal ways to get property in a trust and still avoid probate, if we have to use those, it can create delay, and it will create an extra incremental cost. So that's all I have to say about trust funding. If you have a question about it, please request that review. If you can't figure this out by yourself, if you don't see that it's properly funded as I discussed, but please update that personal information form if you're going to come in for a review. Thanks.